Good morning, everyone. In Business Law 1, I'm going to put up a new video. Why I say new, this is probably the fifth semester of videos I put up for Chapter 3 and through the whole course. So these are new and hopefully improved, and I'm trying to keep them very brief. And how, in part, am I going to keep them brief is I'm not going to do much in the video regarding material I think the book explains well, or I don't think is so salient or important to the course as a whole that can't be understood by a quick reading of the text anyways. So anyways, we're on to Chapter 3, Business, Torts, and Crimes. The basic definition of a tort, and why do you even know this? Many students who are in business want to get to business law, which is Chapter 5 and then beyond. They want to get into the heart and soul of what is a contract and what one can do when they've been harmed as a result of a breach of contract, or if they're the defendant and they're being sued for a breach of contract, what are the potential defenses? We get into that soon. But we have to go to this other aspect of business, and it affects businesses significantly, and it's a legal principle, and the major one's torts. Torts are private wrongs based upon private rights and duties that flow between citizens, businesses, and entities of the like. The government sometimes sues under the theory of tort, but not nearly as much as private individuals and private corporations and businesses do. So civil wrongs upon which the law recognizes there's a remedy. One thing that the book doesn't get into too much that I just want to mention briefly is sometimes we feel like, it goes back to ethics and morals from Chapter 2, sometimes we feel like we've been really wronged or harmed by a competitor or another entity's behavior. But if the law doesn't recognize a cause of action or a right to sue under those circumstances, there's nothing you can do. Sometimes businesses drive hard bargains or are cutthroat in their practices, but if they don't violate a recognized legal standard, there's very little you can do. So just keep that in mind. You have to, and I don't expect you from this class to know when can I sue for every possible potential wrong that I feel or my company feel like they've experienced. That's even after law school. Sometimes someone will come in and say, this happened to me. I want to sue the other party. And if it's something novel or new, or I haven't come across it, I can do some research to see if there is even a right to sue over the conduct that has occurred. So anyways, torts, private wrongs upon which the injured party has a right to sue for damages. In a later chapter, we'll talk about what the kinds of damages you can sue for and other things other than damage you can sue for, like specific performance, telling a party they have to refrain from doing something or that they must act in a certain way. That's not damages. I'm talking about damages. It's money. And when someone wrongs you in the realm of tort, how much money can you sue for? Most of the time in Massachusetts, the most you can sue for is the amount of money you've lost as a result of the other party's wrongdoing. Sometimes that can be a bit speculative, meaning it's hard to measure, but you're not entitled to a windfall. You're not entitled, it's not like you win the lottery as a result of somebody else wronging you. You're supposed to be what we call made whole, put in the position you would have been in, but for the other party's wrongdoing. The thing I'm going to focus on in Chapter 3, the heart and soul of tort law, is negligence. And I'll go in the order of the book. They start off with intentional torts. The reason why intentional torts aren't nearly as significant as one might think in the business realm is it's also overlapping with criminal law. Intentional torts are things like assault and battery, they often go together hand in hand. Trespass, interfering with economic expectation or interfering with contract. I'm trying to think of some of the others that are intentional. Trespass and false imprisonment, which in the criminal realm would be kidnapping, usually have the same elements, not always. Those are all intentional torts, meaning that the defendant, the person that we're going to sue, you have to prove specific intent. They intended to put you in fear of being struck. I swing at you, I miss. You saw it coming, you were apprehensive of a offensive touching. That's an assault. A battery is you've been touched offensively without any just cause or excuse. So if I trip over my own shoelaces and fall into you, that's not a battery. But if I sneak up behind you, I don't know, mad at you, or I'm just a jerk, and I slap you in the back of the head really hard, that's a battery. Well, why isn't it assault and battery? Because you were never in apprehension of being struck. I hit you from behind, you didn't see it coming. Oftentimes they go hand in hand. I swing at you, you see it coming, you're apprehensive about being hit. and you are hit. That's the battery. So these are rarely pursued in the civil realm. They're rarely pursued in business. A couple of reasons why. One is people that do these kinds of behaviors usually don't have a great deal of money to go after. And secondly, they are, again, covered by the criminal prosecutory realm. Restitution often takes a form of remedy, if you will, that many of the victims find, recourse through that. And the other is that insurance generally doesn't cover intentional torts, but they're there. You should know them. And what they outline the elements. The act of the defendant has to be voluntary and knowingly when it comes to intentional torts. Just like it says, it has to be intentional. It can't be accidental. Most torts that we talk about, the ones that you really have to worry about, because most people, intentional torts also have a certain moral component. Negligence torts, no, they're accidental. Big difference. Yeah, the intention to cause the consequences. When I hit you, I intended you to be hurt or offended or in some way taken aback by it, so to speak. And then causation. The injury was caused by the act of the plaintiff. So, for example, I had a case one time, had nothing to do with an intentional tort, but it was a type of tort where after a pretty serious auto accident, there was a deposition later. My client came in in a wheelchair. She recently had her leg amputated. And I always remember the defense attorney asking me, can I speak with you outside for a second before the deposition started? And I'm sure, what's going on? He goes, did she have her leg amputated as a result of this accident? And for a brief moment, I'm like, oh, that'd be great for damages. It was, but totally unrelated. It was a cancer, and she had to have the limb removed before it metastasized, I guess, through her body. But you can see what I'm talking about here. Sometimes I had a case, an intentional tort, but it was in the criminal realm, and somebody punched, my client punched somebody in the face, and they alleged all kinds of dental injury. But we were able to establish that this person actually had significant dental problems from a car accident months before, and the injury wasn't caused by my client. That it's going to be true with negligence too. Part of the big issue is nexus between the event and the harm. Is it actually tied in and foreseeably related? That's a big issue. So intentional torts, we don't do that much in business. I just glossed over briefly. The book does a nice job. Negligence tort, heart and soul of what you really need to worry about. It's actually the heart and soul of what most tort lawyers work with is negligence, because negligence is a standard that's been created through the common law. Remember, the common law is that sort of historical set of precepts we brought over from England in colonial times. Has been part of our culture and society since really eons ago. It's almost an ancient principle in many respects. It's not statutorily created. It's created through the common law or court-made principles where there was a vacuum in the law. There was a recognition we needed to be able to allow people to recover. Other people are at fault for our injuries, whether it's property damage, personal injury, or injury to our business, expectations of profit, things like that. So negligence is classic, and there's always four elements of negligence. First, there is a defendant, person that we're going to sue, had a duty, and we all have duties. We all have duties to act reasonably in certain circumstances. Can my behavior in this empty little office that I'm in right now by myself be different than if I was in a very crowded coffee shop in terms of my movement? Yeah, because it might be more foreseeable that I could bump into somebody and spill a hot cup of coffee, or I could knock them over. And same with, I was thinking about this earlier when I was driving. I was going down in Sturbridge today. It was the heaviest traffic I've seen in Sturbridge, Massachusetts in the longest time. I don't know, tourists, whatever, but it was massive. And I was thinking how alert I had to be because there's a lot of people in the crosswalks. Foot traffic was everywhere. Cars were coming out of the side streets everywhere. Is my duty of care different on a day and in a street like that, where there's a lot of pedestrians, bicyclists, cars intersecting and weaving in and out of traffic, as opposed to if I was on some highway out in Oklahoma where no one's around and I have visibility for miles all around me and all I can see is short, grassy plains to the left, to the right, and into the future. There's no other traffic, no bicyclists, no pedestrians at all. Does my duty of care change in those circumstances? Sure, it's all based upon foreseeability. Sometimes you have to be much more cautious and conservative in your behavior, and other times you can be more freewheeling because of the foreseeable circumstances around you. But we all always owe a duty of care in every situation we're in. And what is that duty of care? To act reasonably. Now, what the hell does that mean? Your opinion of what reasonable behavior might be could be very, very different from mine and somebody else's. I think about he actually teaches at the Mount sometimes too, a lawyer that I'm very close friends with. He and I are very close, and we're almost like brothers now, but he is a very, very cautious individual in terms of how he behaves and how he thinks other people should behave. And I'm not saying I'm, a loose cannon or anything like that, but my expectations of how people should behave in certain circumstances are often a far cry from his. So how do we measure it? We measure it kind of as an amalgamation, sort of a melting pot of all of, humanity's sort of outlook, and we try to come to a consensus of what's reasonable, not what's perfect behavior, because we can always say in hindsight, oh, this person could have been more cautious by doing this, that, or anything. It has to be reasonable. Otherwise, if it's perfect behavior, the cost of doing business would be so exorbitant. It just has to be reasonable, not perfect by any means. Reasonable in terms of finances, cost, time, and all those things that go into place. I think about when I was a kid. I always bring up my father for some reason, but when I was a kid, we used to drive in a station wagon. I don't think we call them station wagons anymore. I don't even know if they make station wagons the way they used to, but we used to have a tailgate that used to lie flat. And I remember as kids, when I was like 7 or 8 years old, when it was in a country town, rural town, probably only 15 or 20 miles an hour. He let 4 or 5 of us sit on the back of that tailgate and swing our legs off the bat as he drove down the road. I don't know about you, but when I have my kids in my car, they used to have these little things inside the door where I can click it so they couldn't exit the car from inside because I was scared they'd like jump out while we were on the road. So standards do change over time, and they change with different people. So we try to. That's why there's a lot of trials over this, because the jury, you don't know the makeup of the jury, what's their sort of philosophical and historical outlook on what people's behavior should and shouldn't be in a certain circumstance. That's what we mean by acting as a reasonable, prudent, which means thoughtful in the context. And I don't always know what it is. And that's why we have trials over it, because we can debate it all day. That was reasonable or that wasn't unreasonable. I got a million stories about my father being unreasonable. But he made it interesting. And then there has to be a loss. I've had this happen one time in my office. Someone goes, oh, I got rear-ended at a stop sign. Good news, when someone rear-ends you, they're always at fault. I'm like, well, not always, but usually. And he goes, yeah, he hit me and da-da-da-da-da. And I said, well, you hurt? He said, no. I said, well, did you damage your car? He goes, oh, I'm not sure. He goes, right outside. Let's go take a look. So I go take a look, and this guy had a car that was the most beat up, dinged up looking car I've ever seen. And we're looking at the back of the car because he said he got rear-ended, and I couldn't see anything major. He must have done one of these nicks or scratches. And I'm like, hey, you're driving a piece of crap car. Whatever damage he or she did to you when they rear-ended you isn't measurable. We don't have a case, even though, so that's, I call that negligence sort of hanging in the wind. You don't have all 4 elements. You don't have an actual loss. So if I've been careless before. One thing I don't do at all anymore is text and drive, because I have to admit it was an attractive, I should say attractive. It was a thing where I think many of us think I can just take a quick look over. I heard the ding go off. I was waiting for a text from somebody. I want to take a quick look. I shouldn't be laughing because there's been tragedies as a result of people looking at text messages. But I remember going off to the side and I hit the edge of the curb and I got 2 flat tires in my car. Now the damages were to me. But what if I went off the road because I was, I don't know, watching a video on my phone or I was texting and I went off the road. My car wasn't injured. No one was injured. Nothing happened. Is that negligence? Everyone's going to say, yeah. Because, well, it's negligence in the sense that I failed to use reasonable care and I breached my duty, but it doesn't have the last element. What's that last element? There's no injury. There's no loss. No one was hurt or injured. Negligence hanging in the wind is not negligence at all. It's just simply a lapse in judgment for that moment. There's no damages. The third one that's the most difficult is something called proximate cause. So say I did go off the road that day and not just sliced my own tires on the curb, but I hit somebody on a bicycle and I ruined their bicycle and I broke their leg. Well, that's obvious. But for my negligence, they wouldn't have had a destroyed bicycle and they wouldn't have had a broken leg. I'm now liable for their losses. That's straightforward. But sometimes events happen and negligence occurs, and there's a real question about whether or not the result was the proximate cause, meaning not just the but-for cause, but the foreseeable consequence of the defendant's actions. I'll go back to my father. I'll use him as an example throughout the semester. He's long since dead, so I guess he can ghost me for talking about him. But when he was getting pretty sick, he died at a pretty old age, but when he was getting pretty sick, there was a story in the news when I was with him and we were watching television together, and he liked to watch the news, and the news came on, there was some kind of anti-inflammatory medicine for people with arthritis was apparently causing heart problems. And my father was taking that medication. And he was being kind of a wise guy, but he goes, there we go, Jim. Hey, we'll get a lawsuit now, because he was having heart failure. And he goes, there's my heart failure right there. And I'm like, well, Dad, you are taking the medication, and the medication could cause you heart problems, but you're also well into your 80s. You did a lot of drinking in your day. You smoked cigarettes back when it was, cool to smoke cigarettes, I guess. And you lived a kind of a hard life, and you were also suffering from something called mesothelioma, which is exposure to asbestosis. And you also had kidney failure, which can contribute to your underlying heart disease. And sometimes people just, what happens to your heart when you get very old, it deteriorates. So I said, Bob, we're going to have a real tough time proving proximate cause. Was there negligence? Yes, they manufactured a drug that turned out to be unsafe. That's negligence. Well, it's actually strict liability because it's an inherently dangerous product. We'll talk about that in a minute. Are they responsible if I can prove damages? Yeah, but you got to prove the nexus. Was it their negligence that caused that injury? Most of the times with a car accident, it's direct, you see it. But sometimes, especially for the property damage, the bumper fell off, I need a new bumper, it's obvious. But sometimes people get in car accidents and they say, geez, after a car accident, I really hurt my back, get an MRI, and they say, geez, we found all kinds of arthritic conditions in your spine that pre-existed probably in all likelihood this car accident. So your soreness and your limitations are probably a result of a congenital deterioration and not the car accident. And that's the debate we get into as well, proximate cause. I don't expect you to be experts on this, but it's pretty difficult sometimes to conclude whether something's the nexus from the negligence. I like that, the nexus from the negligence. The other is also about foreseeability. So when I drive and I'm texting and I go off the road and hit somebody, was that a foreseeable consequence of my lack of judgment? Absolutely. But sometimes we do negligent things where catastrophic, unfathomable consequences happen through a chain or a series of events that's so unforeseeable that it's shocking. So foreseeability is always part of the test. I always use the Simpsons. I don't think are as big as they once were, but me and my oldest son used to watch the Simpsons all the time. Sunday night was a big deal. It came out at 8 o'clock, and we used to always watch the Simpsons. And Homer or Bart or one of the main characters in the show would often do something relatively minor in terms of lacking of care or negligence, but it would lead to a succession. But for their negligence, all these other events happen, and either the Springfield municipal nuclear plant would implode or go to nuclear fusion community, or some other huge calamity would happen as a result of a series of chains of events. But if it's not foreseeable, meaning the initial negligence isn't foreseeable in terms of the consequence, we don't extend liability to the wrongdoer that far. I always think of the example where you ask me if I have an extra pen, I just kind of throw it to you negligently, and I'm careless, you miss it, and because I threw it too high, and the person behind you gets hit, and it kind of scratches their eye, and a little concerned, because I think it got in my, may scratch my, I don't know if it's the cornea, I'm not an ophthalmologist, but yeah, I think I'm going to go down to a nurse, and the nurse says, oh, geez, it kind of looks like you're swollen up. Let's get you over to the hospital. On the way over to the hospital, because you can't see so well, you get in a car accident out in front of the Gardner campus, and you fracture both your legs. Then when you get to the hospital, they need to do surgery. And when they're doing surgery, they have to give you a blood transfusion. And in the process of blood transfusion, it turns out that there's some kind of, I don't know what you want to call it, infirmities in the blood that they give you, and you get a serious blood disorder as a result of that accident. And your legs will never heal the same way, and you're going to always walk with a strange gait or a limp. All from me tossing a pen negligently? I would not be, believe it or not, I would not be responsible for all the liabilities that would occur. I might be responsible for the scratched cornea, but I think beyond that would be a stretch to say it was foreseeable my tossing a pen in class would lead to 2 broken legs and a blood contagion disease. You see what I'm trying to say there? And it comes up quite a bit towards that connection. And then they talk about the defenses, which I always like to talk about. I used to do a lot of tort law. I don't do any of it anymore. One is we don't have contributory negligence. Contributory negligence is sometimes the plaintiff, the one that's been harmed, has contributed to their own harm by being negligent. Like I always think of the thing like two people racing their cars. Well, you're being negligent by racing a car, but maybe you raced well. Your opponent was more negligent than you, but you contributed to the event. In states that I think there's only 2 states that have contributory negligence. I don't know what they are. It's not Mass. You would not be allowed to sue because of your own contribution to the negligent outcome. But Massachusetts, as most states, have something called comparative negligence. There, if I'm the greatest at fault, I'm over 50% or more at fault for my own injuries, I can't recover. It's kind of a fairness situation. So if I'm pretty much, I'm 60% at fault for why I broke my leg, law's not going to allow me to sue. But what if I'm 30% at fault, but the person I want to sue is 70% at fault? That's what the jury finds or the judge finds if it's a judge trial. There I would have a right to sue, but my judgment would be reduced by my proportional loss as long as it's not greater than 50%. If it's greater than 50%, I get nothing. Goose egg, right? 0. If it's under 50% and the jury thinks I'm 10% comparatively negligent or 20% comparatively negligent, they value what my damages are. So they come back at $20,000, but they think I'm 10% at fault. Well, then I'd get an $18,000 recovery. It's pretty straightforward. Comparative, yeah. There's and then there's another one called, I didn't see it in the book though, assumption of the risk. I had a little bit of involvement of this case way back when the mechanical bull. I don't know if you ever heard this. People go and they go drinking and they get on a bull to see if they get thrown off onto the floor. I guess it's fun to watch, but I don't know. I guess people want to show off, I guess. And but this kid was on there, and young man, he was a kid, and he broke his arm, and he wanted to sue. And I said, what's going to happen right away? And we did. The firm I was working with did the lawsuit, and they said the bull was too jerky because it was negligent in its design, and it was too violent, and there wasn't enough padding on the floor. We did a number of things that showed negligence, failure to act as a reasonable person who runs a bull riding operation would do. And I said, I know what they're going to do right away. They're going to say you assume the risk. You were watching people before you got on that bull fly all over the place. You knew of the risks that were inherent in the activity you're about to go into, but you still did so voluntarily and knowingly. And they also, what did they have everybody do that went on the bull? Sign a waiver. A waiver does work, and many of you might open different kinds of businesses. I had a former Mount student, I think. I know he is, but I think he's running something to do with some kind of like one of these recreational places. There's like all kinds of things to do inside, batting cages, trampolines, all kinds of crazy stuff. And it's not crazy, but you can see how people might get injured in these things, and he has them sign waivers because I'll be all set, right? Got to be careful. One is children don't necessarily have the capacity to waive their rights, and I don't know if parents necessarily really have the rights to waive their children's rights. I've always debated about that one. But furthermore, it only works for negligence. So if the defendant was what we call grossly negligence or acting recklessly and wanton towards your health and welfare, the waiver wouldn't work at all. And society doesn't want waivers to always work, because think about it. You bring a kid to an event like that, or you put a bull riding type thing, and people are drinking and they lose some of their voluntariness and wherewithal in the moment, and they're in a dark bar. Did they really read the waiver before they sign it? But waivers do help. If you're in business, think about having a waiver if you're going to be doing something where you think injuries might occur. I was thinking water slide. Did I have to sign up for the water slide? I haven't been a water slide in years, but there's a notice of waiver. We didn't have to sign it, but I remember a big thing on the wall. We used to go to this place called Mesquamicut, and there was a ride there, like 4 or 5 slides right across from the beach. And I took my kids there since they were really little. And about, 3 years ago, it was closing. I kind of grew up with the thing. So did my kids. And so my oldest son and I, we had to run out of there for the very last day that it was open to ride the waterways. And I always remember the sign there, not responsible for injuries, this, that, and the other thing. And those kinds of notice puts you on notice that you're assuming certain risks. I don't know how viable they are. It was a sad day. It was a happy day and a sad day too. So negligence, now strict liability. Now the book, I think, in every book I've ever read about strict liability, gives this impression that, hey, I don't have to prove negligence. It's strict liability, meaning it's automatic. Like, for example, in Massachusetts, if you have a dog and your dog bites somebody, you're strictly liable unless there's only two defenses to it. One is the dog was being teased or tormented by the victim of the bite. And the teasing and tormenting isn't like playing tug of war with a rope or something like that. I mean, it's like being really nasty towards the dog, and then the dog bites you. And the other's trespass. You had a fenced-in area, said no trespassing. Someone hops the fence. They're going to be able to raise the trespassing defense over the dog bite. But other than that, you're liable. You can't say, oh, well, my dog's always been well behaved. It was aberrational. I can't believe it. This person was bitten as a fluke. Doesn't matter. You're liable. It's strict liability. But in the business realm, we hold people strictly liable whenever they're engaged in inherently dangerous activity. You don't have to prove negligence. They could have been acting as the most reasonable, prudent company, business person, whatever. And if injury results, they'll be liable. If what? And this is the thing the book doesn't stress enough. If they're engaged in inherently dangerous activity. You got to prove that element. That's a hard element to prove. I always fall back on the blasting company. So say a company's coming to my community, they're building a new mall near me, and they have a bunch of, I forgot what you call that when there's like giant stone under the earth and initially ledge. There's a bunch of ledge there. So they're going to have a blasting company come in. Let's assume this blasting company is the most responsible, respected. They want to do it right. They take all the right measurements. They put all the right amount of explosive in there. They warn the community by the way the law and the regulations require. They put down those big rubber mats over the area they're exploding to catch all the debris so it doesn't fly anywhere. They do everything by the book. So how did they act? They acted reasonably. They were not negligent. So they explode, and a couple of small shales of rock or shreds of rock come through somehow. Fluke accident, right? And it hits the side of my car, and it ruins my car. It just wrecks it. Goes right through it, goes through the engine. Say my car's a real fancy car and it's real expensive. Would they be liable? Well, not under the negligence standard, because what do you have to prove for negligence? A duty. They only had a duty to act reasonably prudent as a blasting company would. Did they? Yes, I said they did. So no negligence. No negligence claim. And most of you are saying, well, you should be able to recover. Yeah, but the reason why is because they were engaging in an inherently dangerous activity. And that would be fairly easy to prove for blasting companies. Others are more debatable. Are they really involved in inherently dangerous activity or aren't they? Another one that's a little bit more, I think, helpful for you guys is the drug manufacturing world. Drug manufacturers tend to not be negligent. What do I mean by that? They tend to go through a lot of rigor and a lot of testing and protocols in order to ensure that the drugs they produce are not only safe, but they're also effective. And how do we know? Because they have to go through the Food and Drug Administration to determine whether they're over the counter, whether they're prescription, and whether or not they're effective, and whether or not they're safe for human consumption. And if there's side effects, they have to warn the consumer about the potential side effects so people can decide to assume the risk. Oh, if you take this drug, my hair might fall out. All right, if it's going to make me feel better, but maybe all I want is a good head of hair. So I'll decide not to take it. You have to warn the consumer. But have there been drug companies out there that have done everything very cautiously, very carefully, worked with the FDA, didn't do anything sneaky? They produce a drug. I'm thinking about the drug for my dad there for his arthritis in his hands. I picture my father because his hands got all bent when he was old. And he still could yell. He just couldn't hit me. Not that he ever hit me. But he took that medicine after it was FDA approved, and it was all the rage, taking down the inflammation, making his hands move better. But did it turn out to cause some people heart injury? Yes. Are they liable? Most people say, well, yeah, because they caused it. Causation's not enough. If it were negligence, you'd have to prove they failed to act as a reasonable, prudent drug manufacturer did. No, they did everything right. So how can we still sue them? Under the doctrine of strict liability. Because when you're producing drugs that work on the human immune system and the biology of the human I'm not a scientist. Some of you, actually, I have a few nurses oftentimes in business. You know more about the language than I would, but it's obviously engaging in something inherently dangerous in and of itself. So if they screw up, even though they did it all right, we're going to still hold them liable. That's strict liability. It's very, very popular because it relates also to product liability. What do I mean by product liability? Sometimes a company doesn't make just one product and sell it. They make large amounts. They manufacture the goods over and over again. So if you can prove that something they made is inherently dangerous, it opens up a floodgate of litigation. Like there was a car in the 1960s. Some of you might know this guy's name. Some people say it cost Al Gore the presidency. Ralph Nader. Ralph Nader wrote a book called, and the reason why I know this is, well, I am a nerd, but I know this because I collect political memorabilia and I pay attention to politics quite a bit. That's where my political button, not all, but many of my political buttons behind me. But Ralph Nader wrote a book in the 1960s called Unsafe at Any Speed that made him famous. He took on, I believe it was General Motors, over a car called the Corvair, not Corvette, Corvair. And that car could injure you severely in a relatively minor accident. He revealed that. And he revealed that General Motors didn't really care and all that kind of stuff. And it changed the auto industry as a result. My point is once one Corvair is defective and inherently dangerous, all of them are, and it really, really attracts plaintiffs' attorneys, but it also attracts the government. Some people don't like government. I'm not crazy about over government reach either, but at the same time, that's why we have government regulation. That's chapter 4, is because we need to have a sense of integrity in the products that get sold to the consumer, whether it's food or just, car, anything really. You want it to be safe. I'm thinking about my computer here. I'm looking at this battery, and this computer tends to die really fast. I have it plugged in right now, so it's not a problem. But for a while, I remember when laptops were coming out with the batteries, a lot of the batteries would overheat and there'd be these fires. Well, do you really have to prove negligence there? No. If you created something that's inherently dangerous, the thing speaks for itself. In fact, there's a Latin term for it. I hope I don't test you on too many Latin terms other than stare decisis. But it's called res ipsa loquitur. Res ipsa loquitur translates to the thing speaks for itself. I don't have to prove negligence. It's inherently dangerous what you were involved in. Even if you acted as a reasonable, prudent inventor would have, the product's dangerous, and that's the bottom line. So that's negligence. That's product liability, which often relates to strict liability, but not always. Now, interference with a contractor or economic advantage. Careful here. The book does a nice job if you really pay attention, but it really should have highlighted that it has to be for an illegitimate purpose. So say, for example, I'm an attorney and I got a small firm and I'm looking for a nice new associate to work and help out because the workload's getting kind of big, and I'm working with this person from another firm, and I say, would you think about coming over to our firm after this case is over? I think, not to underline our current case or anything, or undermine the current case, but would you come over? We can top the salary you're getting at that other firm by 20%. And the reason why I want to hire them is to improve my law firm. It's literally because I think this person does a great job. I think they're being underpaid where they are, and I think they'd be a great team player at my company. Did I just basically interfere with another party's contract? Yes. Is it actionable? No, because I'm doing it for legitimate business ends. What we're talking about when we're saying a lawsuit over interference with a contract is when I basically pay somebody not to go work with a competitor just to hurt the competitor or just to hurt the business. When I interfere with, they want to lease a new building in my community, and I know this is a great building, but I convinced the landlord not to rent it, not because I needed the building, but simply to stymie or to interfere with their contractual expectation. Sometimes it's not a contract that already exists, it's just an expectation of economic. It's very hard to prove these things because you have to prove it wasn't for a legitimate business purpose. And the other one is economic advantage. They expected to reap so much from a contract that didn't exist yet, but somehow I interfered with their ability to do that by somehow, putting a monkey wrench into the gears, so to speak, and therefore they won't make a profit in that circumstances. There's a lot of lawsuits over this, but they're very, very difficult to pursue. Now the book really shifts gears, and it's about confusion of a source and confusion about a product. One is injurious falsehood, sometimes called commercial libel. If you tell a falsehood of fact, it's got to be fact. I wish the book drove this home a little bit more. And it injures the product's profitability, you could be held liable. So let's say I work for Ford Motor Company, and I say that the Toyota Prius's batteries cause fire and burn the occupants in 1 out of 10 cases. That's not my opinion. That's a factual, measurable statement I just made. And if it turns out to be untrue, they could sue me if what? They could prove my statement somehow being made to the public, or published, if you will, has caused the sale of the Priuses to diminish. Very difficult to do because most people don't say factual statements about a product like that car will break down in the first 10,000 miles and need a new battery. The drivetrain in that car will have transmission problems and require new transmission within 25,000 miles of use. Those are factually measurable. What do most people say about products? Junk, unreliable, it's not efficient. Those are one, opinion, and two, they're not measurable. So under both circumstances, you would not be able to sue for what we call product disparagement. Product disparagement requires falsehood of fact. It's pretty darn hard to do. Oprah Winfrey, by the way, I don't know why I know these trivial pursuit things, but Oprah Winfrey met Dr. Phil in this process. Oprah Winfrey was sued by the beef industry because back on her show in the 1990s, I'm guessing, she would have the show on and she had these like people talking about different dietary things, and somebody was talking about red meat. And she had people saying all these like scary things about, red meat's terrible. And she said, I don't know about you, but I'm not going to eat red meat ever again, and I recommend the same to you. Oprah had a lot of influence back then. Probably still does today. And supposedly, I think the statistics were a massive reduction in meat sales overnight, like something like 10%. They have this so meat prices plummeted and profits got hurt. So the meat industry, I don't know who they are, but they got together. So they sued Oprah. In the process of suing Oprah, Oprah had to prepare, and Oprah has a fair amount of money, and they hired what we call a jury expert. I don't buy them, but they supposedly can look at jurors and figure out by the way they answer questions, the way they look, and the way they sit, and appear what their philosophical and emotional makeup is. And Dr. Phil was supposedly an expert in that back in the day, and he met Oprah, and Oprah and he started the friendship, and that's where the show Dr. Phil started after that. Small world. Oprah won. Well, why? It was only because it's Oprah, everyone loves her. No, that's not why she won, because she did state an opinion. It did hurt the meat industry, but it was just that. It was an opinion. It wasn't a factual statement that this will happen, that will happen. It was like, based upon what I've heard, it's my opinion that it's not safe to eat meat. It's not actionable. You can't sue somebody over opinion. Just can't. Confusion about a source that relates to trademark and service mark, same analysis. Trademark is over a product like the iPhone or this computer. Is this an Apple computer? I don't know what it is, but it's a computer. Whatever the brand, we'll say it was an Apple computer. That company has a trademark, some kind of symbol, word, or combination of the two, maybe even a color scheme that sets it apart from other products of a like kind. They have the right to protect that mark. That's called a trademark. Service mark is the same idea. They don't make a product, they provide a service. I don't know if I can think of any on the top of my head. Uber might have a symbol. I'm trying to think of people that do services. I think there's Stanley Steamer, the steam cleaning company that does the carpets. I think they have a certain symbol. I don't know, I can't think of more service marks. But you get the drift. But think about it. You work really hard to create a product like the Apple iPhone. And it's got that Apple symbol on the back and the whole 9 yards. You don't want other companies to sell products and use your symbol. Well, one is it can confuse the public if they're selling something similar, like maybe a computer or a phone. Clearly is going to cause confusion with the public if you're going to use an Apple symbol and call it something like that. And then there will be litigation over it. And the other is dilution. Say I don't want to sell phones or computers, but I like that Apple name and I like that Apple symbol, and I'm going to use it for selling, a new line of dress shoes. Apple would have a right to sue there too, because you're trying to use their mark to imbue favor for your product, really at their expense, because it can dilute their power to maintain integrity in selling their product. When I was a kid, you don't hear it much anymore, but when I was a kid, Cadillac was considered the car of cars. It was really, really high end. I'm talking like way back when. And there were companies that would come out there and say, this is the Cadillac of, lamps, or this is the Cadillac of desks, or the Cadillac of typewriters. Cadillac would actually have an actionable cause to say, stop using our name in your advertising, even if the public's not confused, because it dilutes the power of their signia and their name to identify their goods from other people's goods. Kind of classic. And there's a whole analysis on page 25 of your book, whether there's trademark or service mark infringement, similarity of the two marks, similarity of the products represented by the marks, similarity of the marketing to customers, the similarity in the amount of advertising used, the area of overlapping use, the intent of the parties in adopting the mark, that's a big one, the strengths of the mark, and the actual confusion by the public, very, very important. I have not seen the new remake, or not remake, but I guess it's part 2 of Eddie Murphy's Coming to America, but the original one had a perfect one service mark over McDonald's. If you remember the movie, I think it was in the 1980s, he comes over from Africa as a prince, but he wants to come over incognito. I don't know if he's searching for a wife or what it is exactly, but he comes over to the United States and he has to get a job because he wants to pretend he's just a regular everyday, American immigrant. And he gets a job at McDougal's, a hamburger joint with the same lit up golden arches M and the same menu, nearly identical, except they wear Scottish garb because McDougal is a Scottish name, but everything else is pretty much the same. And the owner's constantly getting the letters from McDonald's law offices, or the law office that represent McDonald's, giving him a cease and desist to stop using all those service mark and trademark. There's a little overlap there. Symbols and names. Pretty interesting. I'm not going to get too much into business crimes. They're pretty straightforward. Theft, shoplifting, embezzlement, they all overlap. Book does a nice job describing them. These all impact business. What I will mention briefly is RICO, the Racketeer Influence Corruptions Act. One of the things that's interesting about RICO, Organization Act, is that it was designed to take down organized crime, big criminal enterprises. It's gotten much broader than that. It's used by a very powerful tool by the government to close down any business that has been impacted by, criminal activity in some fashion. But it's got to be 2 or more people. I think it's got to be a pattern over 2 or more patterns over 10 years. 2 people, at least a pattern, at least 2 related acts with 10 years of racketeering activity, which is basically any criminal activity that somehow influences or impacts even a legitimate business. And what makes the act so powerful is the government doesn't have to prove by the criminal standard proof beyond a reasonable doubt. All they have to prove is by the civil standard. It's a likelihood or a probability, and they can seek damages and or shut down those businesses because they've been influenced by criminal, investment, for lack of a better way of saying it. Computer crimes book does a kind of a good job there. Computer trespass, pretty straightforward. I do want to talk about copyright. I even pulled up the definition because I thought the definition needed to be spoken to. As copyright is, my friend is doing a copyright case right now. I don't do copyright law, but he's always asking me questions, and I told him I don't know anything about it, but he still asks me. I don't know how bright he is. The exclusive legal right given to an originator or assignee to print, publish, perform, film, record a literary, artistic, or musical material, or authorize others to do the same. Copyright is pretty broad, but it's intellectual property. You created this original thing, for lack of a better way of saying it. It doesn't always have to be in the artistic realm directly. It can be an offshoot of that. And just a funny example that happened to me, statute of limitations run. There's criminal copyright infringement, and there's civil. Most of it's civil. Criminal has to be, you have to do it knowingly, and you have to do it with the intent to gain economic benefit from your violation of the copyright law. Pretty difficult to do, pretty rare. But civil copyright happens all the time, and I'll give you an example where I was involved in it accidentally. I used to do some real estate transactions, and real estate transactions back when I was first doing it, you had to do a lot of paperwork, and the paperwork had a lot of numbers calculations depending on when you were closing because of real estate taxes, because of loan interest accrual, all these things would change if you didn't close on the day you said. Well, in real estate, we think we're going to close on, November 1st, but we sometimes close a little earlier or a little later, so we have to redo the paperwork. Well, now with computers, it's a lot easier, but when I first did it, although we had computers, we didn't really have computer software. Software was just coming around to help you draft those documents and compute those numbers by simply putting in the date. It would do it all for you now. Well, when I was first doing it, I'd be like, I got a real estate transaction. I got to redo all the paperwork because we're closing on a different date now and the numbers have changed. And I was complaining down at court. And there's an older attorney there. And he goes, Jimmy, you don't use, I forgot, I'll just make up an easy soft closing. And I'd be like, no, what's that? He goes, oh, you just put the software into your computer. Back then it was these big floppy disks, 5x5s. I don't know what they were. They're huge. Easily damaged too. He goes, yeah, you put them in your computer and you put in all the information and it will crunch all the numbers for you and it'll extrapolate all the information you put from one form to another so you don't have to rewrite them and use whiteout and do things in triplicate and use the copy machine. It just does it all for you. It's fantastic. And I said, geez, he goes, yeah, it cost me $650. I said, what? And back then they weren't yet as good at making it so when you put in software in a computer that you couldn't just hand it, you could just hand it around very easily. Now, then a little while after that, somehow the disks would read that it had already been loaded up 3 times and you couldn't do it again. But back then it was like a free-for-all. Because why don't you stop by the office on the way back? Because our offices weren't too far from each other. You just tell the secretary, told you to stop by, I'll give her a call. Go pick it up, put it in your computer. I did. It's great. I loved it. And about, I don't know, 6 months later, I get a call from EasySoft. Like a solicitor goes, oh, we see you do real estate transactions. We're a corporate. Goes, oh, yeah, your product's fantastic. Goes, oh, we don't have you down as buying it. And right away, what did I realize? Basically took someone's original idea and creation and used it without their consent, without paying for it, without a license. That's what a license is. And I said, let me get right back to you. I hung up the phone. The rest was that, and I feel really bad about it now. But I think people think sometimes that about music or copying a movie. Or I had a friend of mine used to get movies while they were in a movie theater, like on CD. And I still remember him bringing a movie out to me. It was awful. I don't even want to say what it was, but it was just not good. Although I usually like Will Ferrell, this movie, Semi-Pro or something like that, basketball movie, I did not care for it. Because this is in the movie theater now. And I said, well, how did the CD didn't have anything printed on it? It was like a blank thing. He goes, oh, I have a friend that downloads them or something like that. I goes, what do you mean I have a friend that downloads them? How do you download a movie that's in it? But what I realized is somebody was, when I looked at it, I could tell it was a little fun. Somebody was in a movie theater and they videotaped it and they downloaded it to a CD and they were selling it to people. That's copyright. That's criminal copyright infringement because you're doing it for economic gain, the person that was doing it. Common sense. The friend I'm speaking of is a music writer. And, he's got a song and somebody else wants to play it and there's a question of money. And so we have to figure out how to protect his copyrighted protection. Copyrights, trademarks should be registered. You register them for the federal government. There's an online form to do it. Copyrights can also be registered. Both of them, if not registered, are much more susceptible to being basically stolen or used and you not having a very good right to sue, because why you register it is to show proof. Not only did you were first in time, but that you wanted it protected. You still have some rights, even if you didn't register your trademark or your copyright or your service mark. But boy, it's a really good idea to do so, and it's not very expensive to do it. Copyright, in the sense, by your creation, is automatically protected just by creation, but you really want to have it time-stamped and proven that you were first in time. It really does help. Talks about computer trespassing. Oh, way too long. I thought it would be 10 minutes, 15 minutes. I apologize. Hopefully it's worth something. Let me know if you want me to do videos, if you hate them. Just leave them on as background noise. But I feel an obligation. We're distance learning, that I should at least be talking about this stuff with you in some fashion. Which reminds me, if you're looking at something, you don't understand it, or you take a test and you get something wrong and you thought you got it, shoot me an email, give me a call, shoot me a text. Can we talk about this problem, or can we talk about this topic a little bit more so we can have a dialogue? Emails are tough because you'll email me and I'll get back to you the next day maybe, but I'll really try to be good about getting back quickly. Just try to be clear about which class you're in, because some of you have me for multiple classes, or I have multiple classes and I might not have you in other classes and I won't recognize you by name alone which one you're in. But really, let's have a dialogue. Don't be afraid to reach out and ask questions. Otherwise, be well.